up to 6A, and 6A is the ordinance, the Macomb County Retirement Ordinance, and we'll bring up Karen Thanti and Tom Mashad. And before they give their presentation, would anybody like to make a motion on this? Moved by Lucido, support by Leonetti.
This is all you?
I got it.
You got it?
Okay, thank you. Go
thank
ahead.
you. By way of introduction, my name is Tom Michaud. I have the pleasure of being the Retirement Systems Outside Special Legal Counsel. I've been asked by the Retirement System Board to be available to answer any questions or provide some comment regarding the retirement system. This has become somewhat of a holiday tradition. Last year, I was here in front of the board talking about the retirement system restatement. If you remember back a year ago, the board had some significant changes and adoption of the retirement provisions, but with the thought that the restatement was going to be a codification or a revision of the current provisions. There were a couple of items that were identified as changes, but by and large, the restatement was just that. It was supposed to just update, make more user-friendly the retirement system document so that it made more sense. As sometimes in this process, I understand that you do have two pieces of documents in your packet today.
Okay.
And one I think I'd like to provide some comment on, and the other one is I think is going to just be for information only at this time. But as part of the process, two items were identified. One being, and I understand you have a one-page ordinance amendment that specifically deals with this break in service concept. And so my discussion points will be very narrow in circumstances, and it only relates to those individuals who were members of your retirement system, separated from employment, came back to work, re-entered into your retirement system, but between the time that they left and re-entered, there were changes in provisions. So the question then became, what is the length of service of their break to allow them to come back in? Or when they do come back in, what provisions prevail? Is it the provisions that they were in effect when they were re-employed, or is it a combination of the provisions that were in effect when they left, and then another calculation for their re-employment period? So it's a very narrow topic, and I'm very passionate about talking about pensions. So I understand, though, with it being snowy outside, I'll try to curb my enthusiasm when it comes to this with this concept. But the first item that you have in your packet deals with the break-in service period. And originally, the ordinance, it had provided for a 3-year break. And I understand that there was discussions at the end of last year to extend that to 4 years. And because that was a change, we needed to identify that as a change and put that back in the ordinance. And so that's what this one page does, is it codifies in the retirement ordinance the change from 3 to 4 years, which is what the action the board took last year. The second category are individuals that, as I said, left and came back. And so I'll refer to that as the two possibilities. One is the single calculation, and that's using the provisions in effect when they come back as the operative formula to calculate their pension. The other one I would characterize as a split calculation. Figure out their pension in the first period of employment, figure out their pension in the second, calculate them independently, add them together, and that's what the retirement benefit. And that was a split. The retirement ordinance that was presented as a restatement was presented with the understanding that the split calculation was the common practice, and that's what you had followed in terms of calculating individual pensions when they had a break in service. I'm here today to mention that that was in review subsequent to that adoption, not the practice. The practice was you actually took the benefits in effect when someone left, and that was the calculation. You did not have a split calculation formula. So I'm here a little bit on the technical issue of 3 to 4, that's very clear, very clean. I think it's a little more discussion, from my standpoint, on the change from the single calculation to the split calculation, because it wasn't presented as a change. And I want to make sure that everyone has the opportunity and that it's very clear that, in fact, even though it is in your retirement ordinance now, because that was reflected in the recommended restatement, in fact, that was not consistent with the practice of how the benefits have historically been calculated. So I'm not sure that second topic is something that needs to or will be resolved today, but I think I just wanted to make sure that the board was aware of, originally when it was proposed as a split calculation, that is in your current restated ordinance, but that is not consistent with what the past practice has been. And if you were going to change that going forward and go to a split calculation, that would have to be something that would be affirmatively understood and agreed to and adopted with that understanding. So I know I hit some of the high points, which I'm not sure you consider them high points, but that is the reason I'm here today, to be able to respond to any questions that you have. I can say that some of the information that's contained in your packet is just a draft that was presented by the Human Resources Department. That isn't necessarily what, all the topics that we would, want to highlight for the second category of the split calculation. But because we were just starting that conversation today, I wanted to make sure that I gave you a little bit of an overview and then have an opportunity to answer any questions that you may have.
Thank you. Chair Smith?
Hi, Tom. Thanks. So I just want to run through a little bit of that again so we understand what's going on. This was, except for the underlined sections in here, which I'll get to in a minute, there's 3 different paragraphs that have underlined sections that are actually new, which is what we'll be voting on today. These 3 sections will be the new sections. I'd like to have you explain those changes a little bit too. I don't know if you have, I hope you have that packet, but on page 137 and 138, it looks like there's 3 different sections that have some new wording in it from the old wording, which is, I think you know that. But what Tom is talking about is that last year we passed an ordinance for the pension board, and it said kind of 2 different things. It said we'll do past practice, which is a split calculation. So we understood it was going to be a split calculation, but what we didn't understand was that wasn't the past practice, right? So his conversation there, is more to let us know that if we're going to approve this again, we need to realize that we are approving a split calculation, even though it wasn't the past practice. What we found out after was that it wasn't the past practice. However, we did agree that the split calculation was fine. I don't think we were voting on the fact that it was a past practice, so that's what we were going to do. I'm pretty sure the board, and a lot of you weren't here, voted on it because the split calculation seemed to make sense. So there was some discussion on whether we had to re-adopt the whole ordinance because there might have been a misconception on, was that really past practice or not. But dealing with Scott and talking about this, we believe that it was passed as split calculation. That's how it was going to move forward. So that the only thing we needed to vote on here were the actual changes in the wording on here. All the while letting Tom explain just that caveat in case anybody, thought that past practice was a split calculation. It wasn't. We did think so. I think some people thought so at some point. So I just want to explain that to everybody, that's why this conversation about that's coming up. That's not changing. It was just not, it wasn't presented properly at the time because I think we really didn't realize that was going on. That being said, I hope that makes sense to everybody. But there's 3 sections, and if you wouldn't mind, Tom, just adding like those 3 sections and why they were changed to what they are and maybe what they changed from.
Sure, and if I could add on that, the memo that's presented by the Human Resources Director is really is a supplemental information piece to the 1-page, page 290. That's what we're looking at here.
Okay.
If I could. or Mr. Chairman, could I ask what
Yeah, she's the
I know you've got quite a packet here, so,
Well, no, I think what we were looking at is.
Oh, I'm sorry, 292.
292
I'm sorry,
and
293.
293. The
Correct.
changes are underlined, and we, because that other discussion, that's not here right in front of us right now, right?
right.
right.
The second part of the split calculation is not in this packet.
Just wanted you to touch on the 3 changes that are in here and explain briefly what each of those are before we get the commissioner's questions.
Yes, okay. So the highlighted language in the Human Resources Director's memo are something that, you know, I find are consistent with the current practice, and so these wouldn't be a change or wouldn't be part of the discussion of the split calculation. I think these were just identified as, you know, points of discussion when it comes to the 3 to 4 year. But I can say that these changes on section, or on page 292 and 293, you know, are not part of the split calculation discussion.
Okay,
So
so we're not voting on those
You're not,
today?
no, yeah, that Human Resources memo is
That's just in here, but we're not voting on
correct.
that.
That's just, I think that's for background information. It would just be this one page,
The
290.
membership reinstatement page.
Correct, that would be page
That's
290.
the only thing that we're voting on today.
That's the only thing in your packet.
Okay,
that's
so then we
operate-
don't want to get into anything else, because we're going to come back and unless board
Okay,
members
I
want to
am
talk
not,
about it.
so, point of information, that is not what I was led to believe here. And I'm not sure if, Karen, you're kind of looking a little, yeah, but I would like your input on this, because the 4-year period, was that something that is something that we're changing at this point right now, the period of 4 years? So this is an actual change, the membership reinstatement? Then,
That was something that you adopted at December. I think your counsel is just suggesting that it was adopted by a motion and he wanted it incorporated from a technical standpoint into an ordinance. So I don't have any comments or questions with respect to the 3 to 4 years. I think that was something that he suggested be included as a technical amendment at this point. So that question on the 3 to 4 is a non-issue with that. From my point, that is more of a technical correction, and that's what he's proposing.
we might have to take a look and ask these questions and forward this on to tomorrow, because I was pretty sure we were also voting on these changes that were underlined for a reason in here that were, I know that you say this is a draft ordinance, but this is are we gonna be voting on this draft ordinance? Because that was what was identified as the changes.
Okay, in that case, if we may be voting on them tomorrow, would you briefly touch on each of them?
Sure.
Thank you.
And if you are going to be voting on them, from the standpoint of them already being included in the restated ordinance, if you look at page 292, the first highlighted item would be dealing with the recognition that the retirement system board is a quasi-judicial body. That's codifying the law in the fact that the board may make decisions and have discretion and make decisions on behalf of the retirement system. So that is a legal standard. I'd be happy to get into the detail, but I wouldn't be surprised if you said you take a pass on that lengthy discussion.
For now, yes.
But that's quasi-judicial body. That's already in the system that you adopted in the restatement, and I think that's consistent and wouldn't be considered a change or necessarily needed to be highlighted. The subsection E at the bottom of that page, just as a recognition then that if someone goes from one department to another department or from one division to another division, and that's not considered a break in service. That's just a change in positions, and that because now you have a defined benefit plan basically your defined benefit plan is closed, that someone going from department to department wouldn't trigger a reemployment issue or a break in service. It would just be just a continuous membership non-issue. They wanted to highlight that as a point of clarification. So that would be subsection E. And then if you go to page 293, subsection 18, or section 18, this is just a clarification that if someone took out their money, they could put it back and have their, if they separated from employment, took their money out, and they were reemployed, they would have a period of time to put that money back in and get their service credit reinstated. Once again, I wouldn't consider that a change. That was just a point of clarification that was in the original restatement that shows up in the Human Resources Director's memo.
Okay, so we're going to take questions on all of it because the understanding is those may show up tomorrow on the full board is what we're looking at doing. So Commissioner Leonetti.
Thank you, Madam Chair. So from what I understand with your presentation, the most significant thing we're dealing with on this change is the split analysis.
Correct.
And I don't know, maybe this is a point of information from the board members that were on here last year. Was it the intent of the board to do the split analysis, or was it going to be what was quote unquote past practice? It seems like this decision was made a year ago, and now we're dealing with it again because it was worded wrong, it sounds like. I guess I'm looking for some guidance on the folks that were on here last year. What was the intent?
So my intention that we wanted a split calculation. We wanted it because there were a different set of circumstances, and that was my rationale.
Okay,
May not have been consistent with others.
I'm going to let Chair Smith respond.
And I'll say the same thing I said before. I think the board voted on the split calculation, and the fact that it was or was not a past, the past practice, I don't think had any real significance to it. But because I think that was kind of the recommendation of where we should go anyway. I don't know that we did that because it was a past practice, or that we did it and it just happened. We thought it was the past practice. So I'm going to go with A.
Do we have minutes? I mean, are there minutes we could look at? Just if we pass on this today and look at the minutes.
Yeah,
The
we're just going to move it
minutes,
forward.
but the minutes don't get into, all they're going to reflect is the motion to adopt the ordinance. And if they're indicating that's not in there, the minutes aren't going to reflect that.
Okay, thanks. Yeah, or transcript, yeah.
Well, and I would ask this, the recommendation from HR and from our council is to stick with the split calculation on this, right? I mean, which is also an important point here, I believe.
And that makes sense to me. The question is, why was it still past practice this year? You know what I mean? Why was past practice being used this year if the intent and the recommendation last year was going to be split?
I think it comes down to more of a bargaining issue.
Okay.
Is that the pension board can't grant or deny, they can't change benefits. They just administer what benefits are approved. And as part of that approval process, the whole collective bargaining, even though the retirement ordinance says something, it could be inconsistent with a collective bargaining agreement, and that's where the whole discussion of past practice comes into play.
Okay.
And originally when this body, and I know many of you were not here, when that discussion took place, the draft that they had in terms of the reinstatement identified specific areas that would constitute substantive changes that would kind of go into the collective bargaining realm.
Okay.
And that draft and that version was given to the union representatives to take a review and take a look at it. My comment is more that split calculation was not identified in that draft red line version as a change.
Okay.
Because everyone's understanding was that's just the way it made sense.
Okay.
But in fact, that was not the practice. So to implement that now would be inconsistent with the way that it's always been done. And I can understand, and I take into consideration the fact that this is what you might view as as a recommended plan design issue going forward, but that would necessarily be something that this body would have to work through with the labor issues to make that administratively feasible.
Right, and correct me if I'm wrong, contracts are up in 2019, right? Isn't it? Right. So this would be the idea is that maybe in 2019 we start with the split, or...
Yeah, and so that's kind of why I started the conversation saying this might not be something that is going to be able to be discussed definitively today, but I wanted to start that discussion just so that if someone had a question about why benefits are going forward being administered at the pension board level, not as a split calculation, it would be more because it reflects the past practice And until it's specifically changed, it's reasonable to say that that practice should continue until directed otherwise.
One last question. If we were to pass it now with the split, would that go into effect for 2018, and that could that have any problems with collective bargaining agreements? Would it be the prudent thing to say, okay, we agree with the split analysis, but we're not going to put it into effect until 2019? Would that be the more prudent approach?
I guess one, I have to be careful because I don't want to cross over into making recommendations on the
Right.
labor side of the equation, especially because I have Karen, in arm's length of me. But from the standpoint of the process, the only thing I'm here today is to make sure it's clear that when I was here last year, the reality has changed from what, the past practice that was shared is different than what was reflected in the document.
Okay.
And I want to make, in the spirit of making sure everybody understands, and not everybody in this room, but just everybody in general in terms of the membership and the different representatives, that they have a clear understanding of what happened in the past, what's happened, where you want to go going forward, and that everyone, is of the same understanding.
Okay, thanks. I think you go ahead,
Yeah,
Karen.
I was just going to say I'd like to call Karen up before I call on another commissioner anyway. Go ahead.
I'm done. I'll yield the rest of my time. I'll be glad to hear what Karen says.
Hi, everyone. Good afternoon. This issue really came about when the contracts started changing the tiers of benefits. So for years, an employee would leave the county, they would come back, and the pension benefit was the same. The vesting, the factor, the multiplier, all of that was the same. So over the years, as we brought employees back, they're hiring into a new tier. So all of a sudden then, what do? Stephanie Dobson is not here today, and it is her desire to have the split calculation effective today. And going forward, that's how we calculate pensions, because we don't have a definitive answer. Tom is absolutely right. The ordinance is clear in regards to the split calculation. I can't speak to how we got there. We do believe that it was past practice, but after going through records, there were absolutely no cases that identified the split, and it could be for a multiple of reasons. I'm assuming that it's because we didn't have that many employees coming back who fell into those tiers. Having said that, again, it would be our desire and her desire, especially for the administration side of the pension plan, to go forward with the split calculation. In regards to the labor contracts, if the contracts are silent in regards to the retirement benefits, we refer to the ordinance. The ordinance does have the split. Tom is absolutely right. When we did meet with our unions and our representatives, we did not identify that as a change, but again, I don't think that we knew. I will tell you, when our unions have asked me, do we calculate on split, I've always responded yes. I just assumed too that that's what we always had done.
Okay, Commissioner
you.
Carabelli.
Please don't go too far.
Nope.
I have 3 questions. Number 1, all this stuff in here, you're recommending to the board?
Yes.
You're in concurrence. Number 2, I'm going to go back to item number, section 18 on page 293. It says within 1 year. Okay? I'm confused. 1 year from reemployment. Now, there is an ordinance here within 1 year from and after the individual's reemployment by the county. My thing is that you can't get rehired, I thought, by the ordinance that we have here at the county from 1 year, once you're gone. Am I wrong on that?
No.
Okay.
Yeah, just as a point of clarification, this is simply putting a window for someone to repay their money that they previously withdrew, and it's just saying within a year of their reemployment, they need to put their money back plus
Okay.
interest.
Now, if something, God forbid, happens to that employee within that 3-year period, what's the game plan?
Well, if during the period of their separation,
No, they're coming back, and they have 3 years to pay this in, so within 1 year,
1 year.
they have 3 years to pay it back, correct?
They have 1 year to pay it back.
All right, 1 year to pay it back. So within that 1 year to pay it back, so they can get into that program, God forbid something happens, is that fully vested? They're not getting that benefit?
When someone takes their money out, they forfeit the service credit. So in order to get that service credit reinstated, they have to make payment. So if they don't make payment to the system, then their previous service credit
Won't count.
remains forfeited.
Okay. Last question I have for you. You know, and I go back into, we're the auto capital of the world, right? And when they give a retirement package to union, non-union members, they actually call it a package, a separation package. Gives them the opportunity to collect their retirement, their benefits, everything else, and they're allowed to come back per diem, where the companies don't have to pay that insurance, they don't have to pay all this stuff on those employees, but they pay them cash and they go do their 1099. If we have somebody that leaves and they come back, and we're talking about this split on the two, then and now, are they retiring or are they just leaving?
If I may do that.
You may.
This would be
Please.
someone that is pre-retirement.
Right.
This would be an active employee who separates from employment, comes back to be an active employee before they're eligible for a benefit. And so it's just a matter of they would kind of pick up where they left off.
So nothing to do with retirement, this is just if you don't have, if
Well,
you're
it
not
has something to
vested.
do with retirement, but it has something to do with their future retirement benefits because they're not eligible for a benefit. It's that, and I understand what you're explaining is that if I'm a retiree and I retire and I come back to work, there's a whole different section in your ordinance dealing with that. This is
Okay.
strictly an active employee to an active employee
All right, thank
prior
you.
to retirement.
Okay, on the first round, Commissioner Romano.
I'm confused, and I'm going back to what Mr. Carabelli says, but I'm looking back to Sterling Heights when we have retiree, people that do retire, and they come back, we keep them on for 6 months or 1 year. So the retirement package is intact when they leave the city. When they come back, they're hired as employees without those benefits because they've already had them. Am I correct? And I don't want to assume that in the county's situation, they come back and they start their retirement and their pension all over again and add to what they have. So let me make sure I understand the split. I'm a county employee, I have a retirement package, I leave. I'm gone for whatever period of time. I come back and start working for the county again. My pension starts again and is added to where I was when I left. Well, good, then explain that to me if you would.
Yep.
Short and sweet.
Section 51 is the reemployment of a retiree.
Okay,
And that would be is if they retired and they come back to work for you, they would not be a member of your retirement system. And there are different rules, but that's different than the split calculation that I'm talking about previously. And that would be section, basically section 18, which
okay,
would be.
I got it. They're not retirees, they're coming back as regular employees.
Correct.
As regular employees, they're entitled to whatever the benefits that.
Yes.
Okay, got it.
Yes,
That's all I
thank you.
got, thank you.
Thank you.
Next.
Okay, Chair Smith.
Thanks. I just want to check one thing. So with the split calculation in the actual ordinance, it doesn't refer to past practice in the ordinance, right? That's just a discussion that was going on at the meeting, correct, when we passed that last year. So nowhere in the ordinance is there any legal, any way for someone to go, well, it says split calculation, but you meant past practice, because someone talked about past practice in the past. It doesn't say that in the actual ordinance, correct?
It would not say the ordinance, but you have to read the ordinance in conjunction with the collective bargaining agreements. And then in the collective bargaining agreement,
But that's not our ordinance. I'm talking about what you were talking about to clarify that we were discussing at one point that it was past practice when we voted to actually put split calculation in here, right? And that was the conversation that you were trying to clarify with everybody that, but there's nothing in the ordinance, in our ordinance right now that says split calculation, which is based on past practice,
no,
right?
so there were some areas that were gray in your original ordinance because over time, as Karen had mentioned, you had, by collective bargaining, adopted all these different tiers, and there were all these scenarios that when the original retirement ordinance was in effect, didn't contemplate you're closing the pension plan, didn't contemplate changing the multiplier up and down, or changing vesting requirements. Those things weren't contemplated in the original ordinance. Those are the areas that we tried to put greater detail in the restatement. And when we tried to put greater detail into the restatement, the concept was not to change the practices, but to put greater detail on how you would incorporate the collectively bargained changes into the retirement ordinance to bring it more up to date. And with the split calculation, it was thought that the practice had been to calculate benefits on the two independent
Right.
periods of time. And when we look back at it from a factual standpoint, that was incorrect.
The answer to my question is that it's nowhere in the actual ordinance, so we don't have to change our ordinance. It says split calculations. And I know that was a discussion you were having with Scott a lot. You wanted us to re-adopt the ordinance under the new, or maybe not so new, depending on how you thought about it, belief that this was indeed not a past practice, it's simply a split calculation, and it doesn't matter what the past practice was.
But if I could just look at it from maybe a different angle as well, is that had the facts of the past practice been known back then, either two things would have happened. It would have been identified specifically in the restatement that this is a substantive change, and then everyone would have an opportunity to say, well, we don't want to make that change, or it would have been
Okay, I
got to
understand.
go back to the original and maybe not have been adopted as a split
Right.
calculation in the standard
Okay.
ordinance.
So if nothing else, we can say that the board, by continuing on with this and not changing anything, is well aware that we agree that the split calculation is where we are at, whether it was a past practice or not. And I know that was kind of the argument back and forth with Scott, whether we should re-adopt that section again, just based on the concrete understanding that it was not past practice. That's what it sounded like. So I just wanted to get clear.
I
So
don't
we're
think that
fine.
requires a response, okay?
No, that's fine. We're ready. I'm ready.
Okay, please vote on your iPads.
And pending the vote, happy holidays, Merry Christmas, and thank you very much.
Motion passes 10-0.